just to make her aware of it, and maybe she had forgotten. I'm sure she's done a lot of cases over the last 5 years, and if she to give her the option, or if she felt that she should recuse herself, then give her the option to do it. If she didn't have a recollection of it, and it had no bearing, and she didn't feel it was going to affect her, then that's her call, and she decided to stay in the case. But I felt I needed to make her aware of it and bring it to her attention, and let her deal with it.
Are you going to produce? Are you going to produce that documentation so she still might?
Well,
do you have that document?
We've got a whole weekend. We're going to look at all of our options over the next weekend.
Do this. Will you consider trying to change judges?
Well, we have 9 more days in which to file a motion for substitution. I won't totally foreclose it, but as we've said, as we've looked at this judge and talked to people about her and investigated her, she is somebody that has a very sharp legal mind, very bright, is not afraid to make unpopular rulings. So that's exactly the type of judge we want for this case.
Looking at her versus appearing before her, Joel, are two different things.
One second, what?
Looking at her versus appearing before her, as you've experienced today, are sometimes two different things, are they not?
Well, I like Andy, like Mr. Abood said. This is her first time in the courtroom. It's going to be a big and probably a highly contentious case where she has the state's attorney of the county before her. And perhaps what she wanted to do is put in a firm hand at the get-go in order that she kind of make a statement that there's going to be no nonsense brooked, and we're going to do everything according to Hoyle, which is fine with us.
How did Drew take the news that he's going to be in jail for a while?
He was, I think, a little bit taken aback. He felt, as a lot of people did. I mean, he's not alone in this, that the $20 million is exceptionally high. But Drew's main concern has always been his children. As long as his children are well taken care of, he's ready for whatever life throws at him. And this is just another thing. I think the case is unfortunately going to proceed a little bit faster now that he's incarcerated, as opposed to if he was out. That's going to put an additional burden on us and the state and the courts. But that's how it's go. That's how it's got to go.
Were you taken aback or caught off guard by the breadth of their so-called thumbnail case?
No, there was very little in what they had laid out that surprised us. And to tell you the truth, when you really look at what he said, if that hearsay law is found to be unconstitutional, they really don't have much of a case. Most of what he laid out there is based on hearsay and on that very troubled new hearsay law. And that it be applied both, and to say that it's going to be both constitutional and applied retroactively is almost impossible to believe. And if you knock out all that hearsay, really doesn't have much of a case if that's all he laid out for us today.
Are you saying the hitman allegation was not a surprise?
We've heard talk about that in the past, nothing substantive. Obviously, they have somebody that's come forward. We're going to get the name of that person. We'll do a background investigation of that person. You recall, for example, early in this case, there was a truck driver who said that he had picked up something from Drew, and it turned out that the man was in Louisiana. These type of cases always cause people to come forward out of the woodwork to try to inject themselves into a high-profile situation. Could very well be that case. We need to look at this person and do an investigation and see if they were even around at the time that they said this occurred. So,
one thing about it is this: when you listen to Mr. Glasgow's statements, and he did a good job. He was eloquent, but his statements really focused mainly on motive, and motive isn't an element in the indictment. You can prove motive, but it doesn't establish a prima facie case. What he didn't say, and he either did it because he didn't know or because he doesn't want to say, is how did Stacy die? Kathy Savio die. How did Kathy die? And that's a problem when you have to prove a case beyond a reasonable doubt and say somebody else did it. I mean, that's what prosecutors do in homicide cases, is they explain how the defendant, took somebody's life. And they can't do that. And their argument was, well, he's a master of disguise or he's a master of alias. And I just don't think, in the end of the day, a jury's going to buy into that. They're going to expect, if they're going to find somebody guilty of this crime, that the government has to prove it and to explain how it was done.
And adding to that, when Mr. Glasgow was making his argument, and he was saying, well, there was a house, there was no sign of forced entry, there was no sign of a struggle, I thought he was arguing for the defense. Oh, these are huge these are just, I'm not saying for him to gloss over, these are major, major holes in his theory and a major problem with his case. And you just can't gloss over them. And the jury has to find that that somebody got into that house, committed a homicide without leaving one forensic trace, exited the house without being seen, and was able to, well, and then not have, and then convince investigators from the state's attorney's office, from the and from the state police, that that he had nothing to do with it and was nowhere near the scene during the time period of the death. So, I mean, there's a major problems with this even the way Mr. Glasgow laid out the case today in his thumbnail.
Joe, can I ask you about your other defendant who was in court today, Abraham Karn?
You can ask Ms. Odeh. She's the one that did the arraignment today. What?
It's Mr. Abe Karn.
Can you make an argument? Oh,
No.
Reem Odeh. O-D-E-H. That's spelling my last name.
What were the circumstances of his arrest, and is he guilty as charged?
Well, we pled not guilty today, and the circumstances of his arrest were quite simple. He actually came on his own from the United Arab Emirates without an extradition. It's a country that has no extradition treaty between the United States, so he self-surrendered because he wanted to face the government, because he is innocent and he truly believes that he will fight the charges. Thank you.
Okay. That's what? Chicago's Most Wanted, right? All right, anything else?
Joe, one other thing. In his case, in his argument today, Glasgow essentially said he should be treated differently with respect to bail because he's a police officer. Tell us why you disagree with that.
Well, I know that in sentencing, a police officer is sometimes sentenced harsher because they breached the public trust. But as far as in guilt or innocent phase of a case, a police officer is treated the same as any other citizen. As a matter of fact, there is a jury instruction that is given that the testimony of a police officer is to be treated the same as any other witness. So I don't see how in the guilt-innocent phase of this case the fact that Drew was a police officer has any relevance whatsoever.
Joel, if it turns out there's paperwork to show that she dismissed the order of protection,
Yeah.
she ordered the child support payments and other documents, do you think she should recuse herself, and what do you think the law says?
I think if all that happens, and we're going to have to look into that now, if, for example, she entered a fee order against Mr. Peterson, as Mr. Peterson believes she did, I think that, and the divorce being a key aspect of this case, as even the state's attorney laid out, if she entered a support order and the support payments is a key element of the state's case, as Mr. Glasgow laid out, I do think she should recuse herself. But we have 9 more days to look into that and to ask her to either recuse herself or to use an SOJ, substitution of judge, as of right. So we're going to definitely be looking into this over the next few days.
Is the law clear on it?
There's judges' recusals are somewhat discretionary. It's rare that a appellate court will reverse a case where a judge refuses to recuse herself, but that's mostly because when faced with the possibility of there being a conflict, even appearance of a conflict, most judges will just step aside because the appearance of doing justice is more important almost than anything else. Okay? Thank you.
Thanks, guys.
All right.